Mr. President, may I start with the Court's questions? Judge Bratzer, first of all, asked whether it was the government's case that before there could be any manifestation for the purposes of Article 9, the matter in question or the action in question must be more than merely motivated by and must be mandated or a generally recognised form, and if so, how does the Court go about assessing the answer to that question, if that is the question? My submission is that, that the position is as follows. It does not need to be established that the action in question is a formal requirement in the sense of mandated in its strict sense, but what does have to be shown, because it isn't every act that is covered by Article 9, is that, in the words of the Court, the action in question is a generally recognised form of the religion. That has been the consistent and constant case law of the Court. So we do make that submission. The domestic courts have put that test in a variety of different ways. I say the Court's case law is generally a recognised form. The domestic courts have on occasion used words such as intimately linked to the core values of the religion in question. How does the Court go about assessing that? Well, my submission in relation to that is that it does so by, if necessary, in the case of a dispute, receiving evidence. That is, of course, a matter for the domestic courts if there is a dispute about that. And there's nothing invidious about that, because what one would be looking for and investigating is not the subjective belief of the individual in question, but the objective question, which is whether or not the action that is before the court is indeed a generally recognised form of the religion in question. So we respectfully submit that there's nothing invidious about the approach that asks the objective question. Indeed, it has the benefit of being an objective question. I emphasise finally in answer to that question that in these cases, particularly in the case, for example, of Miss Eweida, there was no dispute. The domestic court specifically considered that issue, and it was common ground and accepted that she was wearing the cross, not, as it were, as a generally recognised form of practice of the religion, but as a matter of pure personal preference. So, to put the point rather more simply, a great many Christians do not insist on wearing crosses either at all or still less visibly. We respectfully submit that our answer to that question is not in any shape or form undermined by the Sahin case, which Judge Bratzer refers to. It's evident, if I recall that case correctly, that when they dealt with the interference aspect of the matter, they dealt with it very shortly in, I think, a single paragraph before moving on. And it's evident from the report of that case, I think, that there was no challenge in that particular case to the interference issue. So we do submit that Sahin doesn't stand, as it were, as authority against the previous clear and consistent jurisprudence of the court, which is, as I've said, clearly to the effect that what is required is a generally recognised form of the religion. And indeed, it might be thought that it's unsurprising that there was no dispute on the facts of Sahin, because the wearing of a headscarf is, I think one can take it as common ground, is a well-recognised form of practice or manifestation for Muslim women. So we respectfully submit that Sahin does not stand in opposition to the test that we propose, which is the right test, recognised by the court and acceptable in principle. Judge Garlicki then asked a similar question, which related to the BA policy in the Eweida case. And I think, again, from memory, someone will correct me if I'm wrong, but I think that the position is that the BA policy was indeed that there should be no jewellery unless mandatorily required by a religion. The fact of the matter is, however, that in relation to BA, first of all, they did reconsider the policy as soon as it was raised in the case of Miss Eweida, and then changed the policy. That isn't, we submit, a recognition that the previous policy was in non-compliant, not in a compliant state with the Convention. It would be a question in every case, and on the individual facts of every case, to assess whether or not operating a policy to preclude a particular form of jewellery or a particular form of item of clothing did or did not interfere with Article 9 rights. The fact that a private employer's policy, previously and before it was reconsidered, was in that form, does not, we submit, and cannot be taken as being some form of implicit acknowledgement that prior to the change, the policy was non-compliant. Indeed, you'll recall the Court of Appeal's judgment, which was clearly and expressly to the effect that before the policy was changed, it as a policy, leaving aside how it was actually applied on individual cases, as a policy was not non-compliant and didn't suddenly become non-compliant when the complaint was raised. But as I say, BA conscientiously looked at the policy when it was raised and decided to change it. On that point, and to interpose a short point by way of reply to Mr. Dingerman's submissions, he made a bit of a point about how long it took BA on his case. I think it was a matter of months rather than anything else, but on his case he made a bit of a point about how long it had taken BA to change that. Well, you will recall again that in the Court of Appeal domestically, they specifically considered that complaint and they rejected any suggestion that there had been any form of unreasonable delay by BA in changing that policy. Once the complaint was received, they conscientiously considered it, they followed their past practice of doing so through the lenses of diversity, and at least one of the reasons, as appears from the Court of Appeal's judgment at paragraph 36, why the thing took so long to change was, in the words of the Court of Appeal quoting the Employment Tribunal, because the claimant's insistence on introducing wide policy considerations forcing a broader range of issues onto the agenda. And that is, with respect to Ms. Eweida, all of a piece with paragraph 3 of the Court of Appeal's judgment, in which they record another express finding of the Employment Tribunal, namely that she exhibited serious insensitivity towards her colleagues, lack of empathy for those with without a religious focus of their lives, incomprehension of the conflicting demands which professional management seeks to address and resolve on a near daily basis. So we don't accept that BA delayed unduly in changing the policy that they did. The second of Judge Bratz's questions, to return to those, was whether or not the government's case was that there could be no interference with Article 9 rights if the applicant's religious beliefs can be reconciled by resigning. We don't put it quite as starkly as that. You'll recall that in the domestic courts, particularly Lord Bingham's speech in Begum, cast the position rather differently by reference to whether or not there were steps that the employee could take without undue difficulty. And we submit that that is the right way of approaching the matter. It is, in terms of the proof of that position, for the employee to assert, under domestic law, we believe, it is for the employee to assert that there would be such undue difficulty, and if there was a dispute about that, the domestic courts would then resolve the factual question. But there was no issue on that front, as we understand it from the domestic court's judgments, in any of those, or any of these cases. The option remained available to them. And we remind the court that there are perhaps two aspects to this part of the interference argument. Firstly, there is the resigning and moving to another job. But secondly, there is the clear and consistent jurisprudence of the court that acknowledges that the person who asserts religious rights may on occasion have to take account of their position. And by that, as we understand it, the court has consistently acknowledged that there is a difference between the professional sphere, where your religious freedoms necessarily abut onto and confront other interests, and the private sphere. And it is highly relevant in assessing interference to note that the employee concerned could indeed pursue all the manifestations, the well-recognised, generally recognised manifestations of their religion outside the work sphere. So we do say that the without undue difficulty test is the one. We adopt Lord Bingham in relation to that, and the way in which that is proved and tested is by the domestic courts on evidence if necessary. The third of Judge Bartz's questions related to the Ladele case, or the Ladele case, and it was whether or not it made a difference that the law changed, in effect, after Miss Ladele had taken up her employment. Our answer to that is no. It doesn't make any difference to the Article 9 analysis. The conditions in many spheres of employment can change, and to turn to there's nothing wrong with employers insisting if they have a contractual right to do so, and there's no dispute that in this case they did have a contractual right to do so. Conditions can change, and employers can insist on employees conforming their duties to new circumstances as they arise. Secondly, more specifically in relation to Miss Ladele's case, it was, we respectfully submit, not, as it were, in any shape or form unpredictable or deeply surprising that the law should move in the direction that it ultimately did, with civil partnerships becoming essentially part of what would be regarded as the normal and core functions of people performing the sort of employment that she was performing. So we respectfully submit the answer to that question is it doesn't make a difference. Judge Hervela's question related again to Miss Eweida, and it asked the factual question, which was whether or not any of us know what it was that prompted the BA change of policy. I imagine there will be common ground around this. As we understand it, the trigger for the change was Miss Eweida's case. There had in the past been a series of different requests by different employees to add particular items of clothing or jewellery, and those had always been conscientiously considered, as the domestic courts found. So her request was indeed the trigger for the change. It wasn't, as I emphasised before, it wasn't any form of implicit recognition, I think, by them that the previous policy had been unacceptable. You'll remember the uniform itself had changed so that there were open-necked shirts and so on for a period of time. But
well, Counsel, you are quite close to the time limit, or frankly speaking, even over the time limit. So please do it in a concise manner.
A couple more questions to go. Judge De Gaetano's question, which is whether or not there is any law in the context of hospital services which allows a conscientious objection. We haven't, I'm afraid, in the time available, been able to get a complete list, but there are some. I think abortion is one, where you can say, I object to abortion and I do not want to participate in that form of it. There may well be others, but if there are, we can no doubt inform the court, but there is at least that one. I think I've addressed sufficiently Judge Vucinich's question, which was about changing the dress code and whether or not BA were implicitly recognising. We say there wasn't any implicit recognition so far as that is concerned. Can I finally respond very, very briefly to at least one set of points by my own friend Miss Rose, or 2 points perhaps. Firstly, in relation to the Dutch document that she referred to, we haven't had a chance fully to consider it, but we do at least put down a question mark about the status of that document. Is it actually a formal government position, or is it advice that the government in Holland is now going to consider? Secondly, and more substantively, what it does indicate is that different countries can take different positions, and these are difficult balances that need to be struck. We note from the document, for example, that the Equal Treatment Commission in Holland, as is recorded in that document, originally took the position that you shouldn't refuse to permit objection on the sort of grounds indicated, and then in 2008 changed their position. So it simply indicates that there are difficult balances to be struck. And finally, we do respectfully reject the underpinning logic of Ms. Ladele's case, which effectively runs, I sincerely believe, she says, that gay relationships are sinful, contrary to God's law, however one wants to put it. I won't do anything that I might consider endorses or promotes them, and I must be allowed to refuse to provide services. But we respectfully submit that that isn't the logic, and nor is it the logic of Article 9 or 14 to say that the mere existence of some other alternative is enough to establish disproportionality. The logic of Article 9 requires the striking of balances with the broad margins involved. It may have been lawful under domestic law for the Council to set up its employment furniture, as it were, differently, but there was nothing disproportionate as a matter of policy about it adopting a policy which gave full rein to the promotion of non-discrimination on grounds of same-sex orientation. Mr. President, members of the Court, I'm sorry to have gone over the time. Those are my submissions.
Thank you very much. I call Mr. Dingemans.
The first question I was asked to address was from Judge Bratzer, and how should the Court approach and deal with the positive obligations, if there are any, in Article 9, having regard to the Jakobski case. I entirely accept the Jakobski case was a case that involved state authorities, but the reasoning of the Court was not limited to the fact that it involved a state authority. If one looks carefully through it, one can see the language of a positive obligation. That is consistent with the Court's own jurisprudence in Otto Preminger, and it would be wrong not to find a positive obligation in Article 9 when there is a positive obligation in, for example, Article 8. Otherwise, you will lead to a system where the courts impermissibly rank rights, and you get to all the problems that have been caused by these cases because people stop treating religious rights seriously. The second question I was asked was about what Miss Eweida had done by way of dress. Can I just read very briefly paragraphs 9.5 and 9.6 of the Employment Tribunal's judgment, just commend them to you. What happened was, well, in fact, because of time, I'll have to paraphrase. In 2004, the uniform changed. Before, she had worn a blouse and therefore covered her neck, and therefore the cross wasn't visible. After 2004, a new uniform was rolled out, and it was called the McDonald uniform. And you could wear either the cravat done up to the neck or with a toggle outside the neck. Miss Eweida started wearing the toggle outside the neck, showing her cross, and that is where the problems started. And the first formal memo where the problem is documented is the 20th of May 2006, and I think that has been submitted to the Court. Also, 9.12.2 of the judgment deals with the mandatory religious items. It said, an employee who wished to wear a religious item visibly outside the uniform was permitted to do so if the item was mandatory and could not be concealed. Obvious examples were any form of headgear, such as the hijab, the turban, or the skull cap. So it's all set out there in the relevant findings. The next question I was asked was from Judge Borgvidsen in relation to the reason for the change of the BA policy. This is paragraph 3.3 of the Employment Tribunal's judgment. A storm of media attention, much of it hostile to the respondent, which was British Airways, led the respondent to reconsider its uniform policy and to introduce an amended policy on the 1st of February 2007. And I think we have also submitted the internal petition that was raised in support of Miss Eweida's position, many from other faith groups. In relation to Judge De Gaetano's question, my learned friend Miss Rose is going to deal with that in some detail. And can I deal with Judge Vucinic's question to me, which is what is the effect of the change, and does it mean it was not proportionate? And we do respectfully submit that it shows that there was never a legitimate aim proportionately pursued in this case that the courts could accept, because incorporated into UK domestic law are the European Convention rights, and the Court of Appeal took the impermissibly narrow route. This comes back to the answer to Judge Bratzer's question to me about the obligations incorporated. The Court of Appeal, we respectfully submit, had misdirected themselves in relation to those matters. And finally, the President's question related again to the wearing of religious symbols and types. And my instructions are that Miss Eweida is aware that many people now wear a cross, but she couldn't possibly give you any accurate estimation as to numbers. those are the answers to the questions, I hope.
Thank you very much. Ms. Rose, please.
Can I deal first with the question that was asked by Judge de Gaetano about provisions in national law in the United Kingdom for conscientious objection? We addressed this in our original application to the court at paragraph 54, where we identified a number of places in the United Kingdom law where provision is made for conscientious objection. These include the right of medical staff to conscientiously object to involvement in abortion, the right of any person to conscientiously object to participation in work involving treatment and development of human embryos outside the body, right of medical staff not to advise on or provide contraception, the exclusion of jurors from jury service on the grounds of conscientious objection, and other miscellaneous rights, including the right of Sikhs not to wear motorcycle crash helmets, which are obligatory for anyone else riding a motorcycle. So those are some examples of where conscientious objection is provided for in United Kingdom law. Indeed, our submission is that the Civil Partnerships Act itself, the legislation at issue in this case, permitted conscientious objection because it did not oblige the local authorities to designate all marriage registrars as civil partnership registrars, but simply required them to ensure that they had sufficient civil partnership registrars in their area for the service of civil partnership to be provided. Secondly, a question asked by Judge Bratzer, is there an interference with Article 9 if the employee is free to seek employment elsewhere? Whether or not that is the appropriate test where the allegation is of a breach of Article 9, and we would say it is not, we submit it most certainly cannot be the appropriate test where the complaint is of discrimination under Article 14, and the question is merely whether the treatment is within the ambit of Article 9. That is because Article 14 prohibits any detrimental treatment on prohibited grounds which is not justified. The nature of the detriment cannot be limited to total exclusion from all forms of employment. It is obvious that an employee who loses their job has suffered a very serious detriment. The logical implication, indeed, of the government's position is the rather startling one that a state employer could have a policy of refusing to employ practicing Jews and say that that was not a violation of Article 9 or Article 14 because other employers were prepared to employ them. We also make the point, of course, that, and this has been raised by counsel for the other applicants in this case, that in the Gays and the Armed Forces case, the issue under Article 8 plus 14 was not resolved by the fact that those individuals could have had other careers apart from careers in the armed forces. And we do ask the court to note the very close links between Articles 8 and 9, because a person's religious beliefs are an integral part of their personal identity, which Article 8 protects. Judge Bratzer also asked the question whether it made a difference that Ms. Ladele was already in her post, and Mr. Eady remarkably responds that it makes no difference at all. We submit that it does indeed make a very significant difference. It makes a difference to the question of the extent to which the local authority was under an obligation to seek to accommodate her, and to the assessment of the proportionality of the treatment to which she was subjected, because the severity of the adverse consequences of that treatment are significantly greater for an employee who has been employed for a number of years and then finds that suddenly conditions change. The fact that an employer is contractually entitled to change an employee's terms and conditions of employment has no bearing on the question whether that treatment by the employer constitutes unlawful discrimination. Contrast the case of Siebenhaar in Germany. That case, decided in February of last year, was a case in which this court rejected a complaint of a violation of Article 9 on the basis that the employee knew when they applied for the job that their religious practices were incompatible with the job. What that, we say, cuts both ways. This employee did not. And the suggestion that she should as simple employee, have been expected to anticipate controversial and novel developments in the law that took place years after her employment is, with respect to Mr. Eady, a startling one. Finally, we make the point that it is not disputed that the service to same-sex couples could have been provided in Islington without any detriment had Ms Ladele not been designated as Civil Partnerships Registrar. The United Kingdom's position is that Islington was entitled to sacrifice Ms Ladele in order to send a message about its commitment to equal opportunities. There are two fundamental objections to that position. The first is, of course, that it defeats a commitment to equal opportunities for the local authority to dismiss the employee who has a sincere religious conviction when it was unnecessary to do so. What they have actually done is to show that they place no weight at all upon the right to equal treatment of Ms Ladele. Secondly, and independently of that, the submission of the United Kingdom entails the permitting Islington to treat Ms Ladele as an instrument for the propagation of its public message. And we submit that to treat a person, an individual, as a means and not an aim in themselves is fundamentally incompatible with individual human dignity and incompatible with convention rights. Thank you very much.
Thank you very much. And Mr. Diamond, please.
If I may just commence by addressing the questions of Judge Bratzer. The first question was addressed to, I posed to answers about Mr. McFarlane and his position. His position was he did not particularly think or address the issue of what the nature of psychosexual therapy would involve. He planned to specialise in sexual therapy, ultimately in private practice. His own views of his position on this were uncertain, as we've discussed. They had been previously resolved, and he believed they would be previously resolved again. If they were unable to be resolved, he hoped that civilized people would have reached a sensible accommodation. But there's a few points I just want to mention on this. The first thing is that Mr. McFarlane has been banned now from a number of reputable therapeutical bodies because of what took place to him. He's unable to join a mainstream organisation, and this is having a far-reaching prohibition on his professional practice. In the case of Sid Abros and Lithuania, 2004, the Lithuanian government introduced a wide-ranging employment ban on former KGB officers. That was held to be disproportionate because of its wide-reaching effects under Article 8, not Article 9. I'm going to come on to that in a minute, the same as my learned friend Mr. Dingemans has addressed. But it affects his Article 8 rights to have a career, have professional colleagues, and provide for his family. Similar considerations of the widespread right. Not only do we have a religious bar to office, but additionally to that, we have a denial of choice of autonomous individuals who may have wished to see Mr. McFarlane. I mean, he may well have specialised in a particular type of therapy, particularly those from a religious community, and they may have wished to have obtained his professional references. And finally, the question of referral is the question of therapists saying, I'm too busy to see this person, is very normal. Therapists refer all the time. They're not experienced enough. They're not specialised in that field. They themselves have an issue of abuse or alcoholism, which the patient, they go on holiday, they move home. Referral is normal and should be extended to religious grounds. On the issue of public-private employment, I endorse the grounds again raised by my learned friends. We feel that if additional grounds are given to the state, that will privilege public employees under the Convention over private employees. We say that's wrong in principle, and it would result in a partition of Convention rights in a highly regulated field. There's significant amount of legislation in the United Kingdom on employment law, which tends to treat public and private employers similarly, and the United Kingdom has introduced legislation in this field, inequality, to prevent discrimination, likewise, on grounds of religion. Article 1 requires the state to secure the rights under the Convention to all persons. That will not be achieved if a whole sector of the economy is excluded. If we take the case of Arts vor den Leben, I digress perhaps, you have a right to demonstrate, but other groups can appear and prevent you demonstrating. The state is under a positive obligation to enable you to demonstrate or manifest your religious practice. The Convention has been applied in many circumstances to employment. We have Article 10 applies. There was Sachas in Spain where Spanish trade union degraded their employer. They were dismissed, but Article 10 implied. There's been other cases involving whistleblowers. The question is, we have cases on Article 8, and I've mentioned Sidabros and Lithuania, and we've also had SUS and Germany, where the court had to do an Article 8 analysis where a church dismissed an individual for having a second family. All these cases involved a convention right in the employment nexus. What is so special about a national authority saying, you have this right, we will do a proportionality analysis and judge where it's going? The only petitioning in my submission that should exist in the labour market is not between public and private employees, but between ideological employees and normal employees. Mr. McFarlane's employer is an employer. He has no ideology. Perhaps a church, as in Sush's in Germany's case. Perhaps a political party, you have to be committed to socialist or conservative ideology. Perhaps Friends of the Earth, you should be committed to Friends of the Earth ideology. But the final point is conscience clauses. My learned friend, Mrs. Rose, has read the list. We stand by that. But we just draw one point. The exemption clauses were quite wide. They covered a wide range of areas, including Sikh helmets, jurors, and medical staff. The court in Batanian, in Armenia, founded the objection to military service on an Article 9 approach. There's no reason to limit that case simply to military service. What's so special about military service? Many people have deeply held conscientious views on very sensitive issues, and none is more sensitive than the field of religion. Thank you so much.
Thank you very much. Any other things to say? Yeah, Ms. Edie.
Just before this hearing closes, and it relates not at all to the facts or issues arising in this case, but word has reached us that this is Judge Bratzer's last live UK hearing, and however much his modesty may wish it, that cannot be allowed to pass without something being said on behalf of us all. And I emphasise that this isn't simply me saying it, this is on behalf of all of us. Judge Bratzer has, as the court will well know, been at the forefront of human rights development from its early backwater days, if one can describe it thus, to where it is now, at the heart of European decision-making, infusing almost every decision taken by almost every public authority across Europe and beyond. Before he became a Commissioner of Human Rights, Judge Bratzer had appeared in over 100 cases before the Court and the Commission. He then became the European Commissioner for the United Kingdom, was then elected to the Court when the Court was set up, and now, fittingly, just before his retirement, is its President. All of his work on this Court, certainly from the perspective of those who have appeared before it, has been done with intellectual rigour, with humanity, with a characteristic generosity of spirit, and the twinkle that over the years has forgiven at least my very worst points. It has also come to our attention that Judge Garlicki is to leave the court as well, and everything that I've said in relation to Judge Bratzer, of course, applies equally to Judge Garlicki. We wish you both very well in whatever you choose to do hereafter.
Well, thank you very much for these nice words. Of course, it's always a pleasure when such words of proper recognition arrive from our native countries, and this was a very nice accent to terminate this hearing. Anyway, we now come to the end of this hearing. I thank the parties for their interventions and answers to the court's question. The court will now deliberate on both the admissibility and the merits. The judgment, or as appropriate decision, will be delivered later. The parties will be informed of the date of delivery. I declare the hearing closed.